find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh because of his dire financial situation, the threat of being exposed for committing the crimes which he was later charged with, resulted in the commission of the alleged crimes.
That was the ruling today, at least part of it, from Judge Newman, admitting the evidence, saying that it will be allowed in this trial against Alec Murdaugh. We have trial attorney Carl B. Grant back with us. And Carl, let's just start off right off the top and say this is exactly what you told us last week that you expected would happen. The judge citing his dire financial situation, the threat of being exposed. So now, your assessment of what this means for the prosecution and the defense.
Well, for the prosecution, it means that the rug has not been snatched from under them. In other words, they can still proceed with the motive that they articulated to the jury in the opening statement as to how they're going to proceed. Can you imagine if he'd have said they can't use that evidence? Now the prosecution made a promise that they definitely cannot keep. So they can now proceed with the motive. For the defense, naturally, you just got to put this in proper perspective. How does it relate to the actual charges? Is any of this evidence needed to prove the elements of the crime? So that's the evidence that they're going to take.
Wow.
And so, Carl, how does this work? So the evidence that we were hearing while the jury was out, some of those witnesses can now be called back to the stand and the jury can hear them? Yes,
that's exactly what it is. Like I said, the in-camera or out of court, out of the presence of the jury hearing, the purpose of that was for the judge to evaluate the evidence to determine its admissibility under the rules of evidence. Now that he's completed that process, those witnesses will be allowed to testify before the jury.
And I want to talk about some of the testimony we heard today. The woman who was charged with taking care of Alec Murdaugh's mother testified. She got very emotional at one point on the stands, but it will prove, I believe, to be critical and key testimony because at one point she testified about what he was wearing. Let's take a listen to that and then we'll hear some insight from Carl.
Do you remember what he was wearing?
Shorts and a t-shirt.
Do you remember what kind of shoes he had on?
Those cloth shoes, like Sperry's, that type of material. Like Sperry's, that type of material, cloth shoes.
Cloth shoes?
Yeah, like cloth, to me, yes.
And you said something called Sperry's?
Something like Sperry's, that, you know, that kind of, but it was cloth. Okay. That kind of, yeah.
Wasn't boots?
No, it wasn't boots, no.
And are you familiar with tennis shoes?
Yes.
Was it tennis shoes?
No, it wasn't tennis shoes.
Cloth, Sperry type shoes?
Yes.
Did he have any socks on?
No.
So, Carl, I want to ask you what you think they were getting at there, but also we heard testimony where she talked about where Alec Murdaugh tried to kind of put pressure on her, for lack of a better word, in terms of how long he was at the house, closer to 30 and 40 minutes versus 20 minutes.
I sympathize with this poor woman. Can you imagine the predicament she was in? She had to be as nervous as a mouse on a hot tin roof.
My goodness.
She's in the courtroom testifying, essentially for the prosecution against her employer, who's been charged with double murder. That's a very tight spot to be in, considering also the name and the influence that that family carries in that community. So I know that woman had to be very, very nervous. Yes, her testimony is going to be very compelling. The situation of him saying, make sure you understand now, I was there for 30 or 40 minutes. That's like a reminder. You're my alibi. You're the person I'm relying upon. And I was there for more time than I really was. And she testifies, of course, that no, he was only there for 20 minutes.
Right.
So that's very compelling.
Yeah, and she also testified to Alec Murdaugh bringing something to the home that night. Something blue is what she described it as. We heard earlier from the prosecution and the defense, one saying that it was a tarp, one saying that it was a blue raincoat that they actually showed as evidence inside of the courtroom today. How does the jury make sense of all of this, and what exactly is the prosecution getting at this point by bringing this evidence inside the courtroom?
The prosecution is trying to establish what he was wearing that may have some gunshot residue on it, or some other evidence that can prove that he committed the crime. And of course, she's there to testify that she saw what seemed to be a tarp, and there's a lot of inconsistency in her testimony.
Right.
And I think it's because the woman was really so nervous. She was given various times as to when it happened. The way you handle that, though, as a trial lawyer, is you use the recency primacy rule. In other words, okay, ma'am, you may not remember all the details now. Let me take you back to what you said the day after you were interviewed or 3 days after this incident occurred back then. Is your memory better back then when you gave this statement, or is it better now? Clearly, she's going to say, is anybody? It was better then. So that's the way you handle that. And when you go back to it being better then, guess what she said? 20 minutes.
She said 20 minutes.
Kind of holding her hand to take her back to that time. Because
Right.
obviously, like you said, she was nervous.
I felt for her while she was on the stand today,
did
though,
I.
as you mentioned, just so much pressure. So, Carl, as we look at this now in terms of the timeline of this trial, now that financial crimes have been admitted, how does the defense respond? How do they defend against that? And how much is that going to extend this trial?
It depends upon how the prosecution is going to proceed. I always say, and I've argued this to the jury more than once, I feel like the prosecution is trying to stone my client with popcorn. If that's all you've got, then you don't have much. So the prosecution has to be very careful. They must use the most substantive financial crimes and evidence thereof in order to keep the attention of the jury and do not make the jury think that they're wasting their time. So that's what they must do. Now, for the defense, get back to your basic underlying defense. That is, so what? You're proving these financial crimes, but does it really prove that this was the basis for him to commit these murders?
And as you've reminded us from the very beginning, that motive is not necessarily needed when it comes to a murder case, but I guess for the prosecution, if they add it, it could help.
Oh, no doubt about it. Because, see, think about the way common people think. The first question they logically ask is why? Why did the person do especially such a horrible crime? Why did he do such and such? And that may be the first logical question that they'll ask in the jury room. So that's why you may not need it legally, but logically and just common sense, you want to have it. Like I said earlier, it's better to have it and don't need it than to need it and not have it.
We got about 30 seconds left. As you talk about warning about wasting the jury's time, if they drag it out too far, they may forget some of the compelling testimony that they've already introduced into evidence. But what do you think now in terms of the timeline for when this could go to the jury?
Sure. Well, now that the financial evidence decision has been made by the judge, clearly the prosecution is realigning its witness list. Which witnesses will they really call? I can't see this ridiculous 200 plus witnesses that they initially had. I can't see them sticking with that. So they will call the most important witnesses to establish the underlying argument that they need to establish the motive, and then they will probably move on once they get all of the other substantive evidence in. So now, with that being said, I imagine, if you will, the prosecution case could probably take maybe 1 more week or less.
Okay.
Then you have the defense. Then the defense got to decide how they want to proceed and what experts they'll put up.
All right, Carl B. Grant laying it all out perfectly as always. Thank you so much for breaking this down and making this understandable.